focus on affordable provision in the rural areas and specialising housing types for the older population. So there is indeed a housing objective.
Yes.
But if you look above it, there's also a sport and leisure objective. Now, there is no indication in the local plan, is there, that one objective overarches another?
I accept that.
Thank you very much. Thank you, Madam. That's all I have.
Thank you, Mr. Richards.
Okay, thank you very much, Mr. Richards. So, now we're going to turn to the Real Six Party. Mr. Humphreys, would you like to commence your re-examination, please? Your cross-examination, sorry.
Good afternoon. I don't think your mic is on.
You're on. more luck than Judge. Mr. Hooper, I saw in your proof some amusement that you wrote your name as Hooper, but I thought there might be a Freudian typographical error. So I shall pass on to more serious matters. The first matter, please. You tell us that, and I'll say at the outset, I'm not going to go through all the evidence put by other experts or those who've given evidence. I'm going to concentrate on the planning policy elements and other related matters that you refer to in your appendices and so forth, insofar as possible they're within your own knowledge. But you tell us that you were, I think it was 9 years ago, made the Chief Executive Officer of DPP.
That's correct.
National Ward Town Planning Consultancy, and indeed after only 13 years of professional experience. Yeah?
That's correct.
And no doubt you keep up with changes in legal and policy framework.
I do.
Yes. In paragraph 2.2 of your proof, you draw a distinction, this isn't the only part, but I'll take you to 2.2, you draw a distinction between what you referred to as the relevant development plan and the neighbourhood development plan. Do you see that? 2.2, you say the relevant development plan is the Rugby Borough local plan, and then you refer to the Brandon and Brentford neighbourhood plan is also in effect at the appeal site.
Yes.
And if we just look on to paragraph 2.35, you say the development plan confirms there's a housing need, ... and then the second sentence, the neighbourhood plan supports this objective. You see that?
Yes.
And when you get to 237 on the same page, the development plan does not consider sports stages community facilities, ... The neighbourhood plan does include Brandon Stadium's community facility. Were you not aware that the development plan includes the neighbourhood development plan?
Yes, as a whole.
Yeah, it includes it, and therefore those statements are inaccurate, aren't they?
Yes. There's an error on my part to refer to the development plan rather than the local plan.
Yes. The development plan comprises both the local plan and the neighbourhood development plan, particularly for there could be minerals, etc., but that's not part of this case. And that's been the case since the Localism Act of 2011, which amended Section 38 of the 2004 Act, Section 38.3. Next point, please. You refer to new homes bonus at your paragraph 2.6.14. Should I say that? Let me just check the reference.
don't think I ever...
Sorry, it's not. Sorry, the 2 is... it's 6.14. Sorry, just my... Yes, you refer to the local authority revenue of new homes bonus. Just help me with this, and a figure of £915,000 of payments over 4 years. Help me with this, please. Do you say that new homes bonus, the payment of that is to the council, is necessary to make the development acceptable?
No, I don't.
And so you know, because you keep up with policy, that since 2014, in every iteration of the PPG 21B since, in relation to planning applications, no weight is to be given to the receipt of new homes bonus because it's not needed to make the development acceptable.
I accept that point.
Thank you. Madam, for your reference, it's PPG 21b-011.
I'm very familiar with.
I know, but I can't think of a single inquiry that I've been to in the last 9 years when I haven't had to raise this point. There we are. Now, Madam Inspector referred a few moments ago to the reference in my learned friend's opening to some, in relation to public open space, of there being an increase over the existing of some, or 370% is the figure, I think do you remember that?
Against policy requirement, yes.
Against, over policy, over...
Yes.
Yeah. Now, again, do you say that going above policy requirement by 370%, if that's the way it's put, is that more than is necessary to address planning harm?
It's a benefit of the proposal.
But it's more than is required, isn't it?
It is more than the policy requires.
And therefore, if it's going to be secured by the Section 106, is that right?
The open space. So this is separate from the pitch.
Yeah.
I appreciate.
I'm well aware of that. Yes. Is that going to be secured under open space as condition or Section 106? Your understanding?
Yes. So 106 in terms of the opportunity of the authority for it to be transferred to them.
Just help me with the 370% increase you refer to, and I'll just don't want to remember. It's paragraph 29 in Friends' opening.
It's my proof of evidence.
Yeah.
Paragraph 6.25.
6.25. 6.26 there, thank you. The above table demonstrates, and so that's not, you're saying that's more than the, sorry, let me start again. Do you say that includes the pitch or is more than the pitch?
No, that excludes the pitch.
It excludes the pitch, quite, that's what I thought. So the 370% more than open space, and that's going to be secured, I'm happy to do it, whether it's secured by the planning, by an obligation or condition. Do you think it's the obligation? I'll take it on that basis. Regulation 122, sub-regulation 2 of the Community Infrastructure Levy Regulations says the planning obligation may only constitute a reason for granting planning permission if the obligation is A, necessary to make the development acceptable in planning terms. And you're not suggesting it is necessary to make it acceptable in planning terms, are you?
No.
No. And therefore, it would be unlawful for the decision maker here, for the inspector, to take into account. So you can't give any weight to what you refer to as a benefit, can't you?
Obviously, subject to the discussion in relation to that transfer point, in relation to it being a contribution, in that land being transferred to the authority.
No, but irrespective of whether it's transferred, you're saying you're providing public open space, which is 370% more than which is required.
Yes.
Yeah. Very well. But you are familiar with the SIL regulations?
I am, yes.
Yeah. And if it's not necessary to make the development acceptable in planning terms, I don't understand you to say that it is to provide 370% above requirement, then it can't constitute a reason for granting planning permission.
We are not suggesting as a reason for granting planning permission. It is an additional benefit. The weight to be apportioned to that is
what?
Is at the inspector's discretion.
But the inspector, no. You're tempting the inspector to err in law, aren't you? Because if it can't constitute a reason for granting permission, no weight can be given to it, can it?
I think my understanding of the point you were making is in relation to it in respect of a transfer or a financial contribution towards the management of it.
No, I'm not. I'm saying the provision of 370% over and above. Whatever the arrangements are, it doesn't really matter to me. For present purposes, I'm just saying, you're saying, look, we're giving you 370% more than is required. Give a benefit and give weight to that. That's a benefit and give weight to it.
But if that land didn't transfer to the authority...
Are you still saying it should be, so in which case, but is it going to be a part of the condition that has to be public open space?
In terms of access to that, but in terms of the point that I think you're making is in relation to the ownership, the transfer of that.
No, I'm not.
Can I just stop you there? I don't think we're making too much progress. I think Mr. Goatley, you want to make a point.
Yeah, if we're going to be dealing with what does or doesn't constitute a material consideration, as opposed to matters relating to the weight that you attribute to such matters, and the application of SIL 122, that's a matter that we can deal with in submissions at a later stage. If it's contended that simply what is being contended is factually incorrect, or that it's a matter that you are not entitled to be informed about or to know about because it's immaterial, then that's a matter which I would certainly take issue with as a matter of law. But we'll see where otherwise this goes. I'm not sure for these purposes it's going to help you if this is otherwise not going to be a matter dealt with in submissions.
I'll take the point. Yeah, Mr. Humphreys, if you just bear that in mind and continue.
Madam, it is important for you to, it's important for you to be aware that you're being asked to give weight to a benefit. We can argue, we can take that further. Legal submissions, but this witness is asking for weight to be given to that benefit, and I'm asking him as someone who's experienced in this field whether he's asserted weight should be given, although he puts it now, what weight you give to it is a matter for you. But it's an important point because, as the Supreme Court made clear as recently as last year, we are not in the business of buying and selling permissions. You do not offer, the local authority can't require more than is necessary to make the developments acceptable in planning terms and reasonably related, fairly related, etc. If you start giving weight to something, you're erring, the potential is err in law, and the policy reason behind that is that it stops developers, it could be a local authority on another day buying, but it stops developers from buying a permission because they're saying, here are all the goodies that you want, and the council say, well, thanks very much, and the planning policy gets forgotten. That's all I'm saying. I'll pass on because I don't think this witness can take us further, but let me just put the same point, although it's a planning policy point in the NPPF, it was a condition, then we'd be applying paragraphs 55 and 56 of the NPPF, and again, local authorities have to consider whether they should only impose conditions where they are necessarily relevant to planning and to the development to be permitted. Okay. Right, coming on from there, you were appointed, you've told us, in June 21. Just help me, small point, was that DPP's first involvement?
In Brandon Stadium?
Yeah.
Yes.
Because I say that because when I looked at the planning statement, it was dated December 2020, but it may just be it was an old sort of template you're using. CD 254 if you need it. But anyway, that's fine. Were you then advising clients at Swindon in relation to relocation of Swindon to a new site?
Not at that point. No.
Not at that point. And when did you get involved in that?
my involvement in that project commenced in mid to late 2022.
Cool. Now, you've told us, when, in answer to a question from a learned friend, as an aside, that you have a developer partner on board. Is that right?
That's correct.
And do they have? Is that a house builder?
It is a strategic land and house building business. Yes.
Strategic land and sorry, who was
St Phillips.
St Phillips. So that strategic land and house builder. So they be building?
Yes.
And when you say on board, the latest version of the Section 106 draft that I've seen doesn't include any, suggest there's any legal interest that anybody else has. Is there a conditional sales contract?
Brandon Estates have an existing relationship with St Phillips. Contractual business relationship.
Business, but they don't have an interest in land in Brandon Estates at the moment. In the land at the stadium, they don't have any legal interest in it.
I'm not that I am aware of. No.
Well, because if they did,
they would need to be part of the agreement.
Yeah.
Yes.
And so, just so that I can be clear, then, when did St Phillips, Strategic Land and House Building Company, when did they?
At the point that the application was amended to reflect details being considered at this stage, the details in relation to the house types are their house types.
Thank you. I mean, I assume that because it'd been slightly odd to be seeking detailed approval for the layout and the design if you didn't have someone in mind who might take it.
Yes.
Yeah? But if they don't, are they contractually bound by this business relationship to actually, this contract you referred to actually go ahead and to buy the site?
To deliver the site, yes, as I understand it.
To deliver.
Yeah.
What you say, you understand it. There's no legal interest. What's the nature? Could perhaps if you could find out outside of the inquiry, just let me know.
Can I just ask, what's the relevance of this to me for my decision?
Well, it's important for you to know to consider deliverability. Right? So if just bear with me, madam. These are fairly typical questions that need to be asked to establish before we. So we've got a complete picture of what's happening. You're being asked to give weight to a number of matters, and deliverability is fairly fundamental as set out in the framework. Just help me with this. Yes, I think it was yesterday, it was suggested that there's a registered, I think Mr. Stacey referred to, that there's a registered provider who's been identified for the affordable housing.
That's correct.
Yeah. They haven't signed up at the moment, I dare say, but they've been identified.
They have expressed a written interest.
Are they local to the area?
I believe so, yes.
Yeah, okay, cool. And just help me, when the landowner, whether it's you or St Phillips, sell to a registered provider, the registered provider gets a discount.
Yes.
Is that right? And is that something in the region of 30 to 35% of market value?
I don't know.
You don't know? Would, well, if you don't know, in terms of the, do you understand the discount would be any different if you're selling something through a discount market sales than through a registered provider?
I do understand the concept, but yeah, I'm not a affordable.
Okay.
That was Mr. Stacey.
The reason I ask about discount market sales is that Section 106 suggests that discount market sales might be permitted if there's no willing registered provider, for example.
Yeah, as a cascade mechanism.
Yes, as I understand it, then the sale would be direct to an individual purchaser, but obviously that purchaser would have to be a qualifying purchaser under the discount market scheme to be agreed with the local authority.
That's it. All to be agreed with the local authority through the cascade mechanism.
Yeah, that's fine. But that would be sales rather than rent. Is that right?
As I understand it, yes.
Yeah. So, Madam Inspector, just to help her, in terms of thinking about social rent, if it doesn't transpire that the registered provider, then indeed we can look at the 106 in due course. But the that would discount market sale would preclude on that basis social rent, wouldn't it?
Yes.
Okay. Could you take up, please, CD 260, which is the Viability Assessment Addendum, which was prepared by CBRE and submitted to Mr. Bergwin of Brandon Estates on the 18th of February 2022.
Yes, I have that.
Now, I think that the PDF and internal page number will be the same, which is page 8. There's a letter at the beginning of this document and then various appendices. Madam, I don't know whether you've looked at this before, but whether I can take it faster, or are you familiar with it? Thank you very much. Thank you. Well, if we just turn to page 8, please, the conclusion. The appraisal results demonstrate that the proposed development cannot viably accommodate provision of affordable housing and the estimated Section 106 planning obligations, whilst achieving the minimum risk-adjusted developer's return and the benchmark land value. The commercial decision whether to proceed with the scheme and or to deliver a policy-compliant affordable housing provision will therefore be at the discretion and risk of the applicant. As supported by national planning policy and guidance, given the commercial risks, it would be CBRE's recommendation that the proposed development does not incorporate any affordable housing units or a payment in lieu of on-site provision or any sums towards planning obligations. Yeah?
Yes.
Okay. Now, CBRE were assuming in that case, and we can see this at the top of page 7, they were assuming that this would all be discount market sales, the affordable housing, weren't they? Just to help you, I come back to page 1, and I'll just just to help you with the context, because you may not have looked at this for a while. Have you looked at it recently?
Not recently.
No, okay. Fourth paragraph, I think, or third paragraph, beginning of viability assessment. Originally, the original one by Turley was July 21, submitted in support of the revised scheme. That concluded the proposal was unviable, whilst incorporating a 20% affordable housing provision in the form of discounted market sale at a 25% discount to open market values. And Section 106 planning obligations then approximately 1.33 million. All right, so just for present purposes, just discount market sales being in the mind, yes?
Yes.
And if we then go on to top of page 3, it's understood, tell me when you're there.
Yes.
It's understood that in discussions with the council regarding the proposed development, they've expressed that an affordable housing provision in the form of discounted market sales housing, DMS, sought at a 25 to 30% to open market value in rural areas would be acceptable. As a starting point for this assessment, CBRE has adopted a 25% discount to open market value for the DMS units. So we can see that what's set out in this appraisal is on the basis of these being DMS units at a 25% discount to open market value. That's the basis of their appraisal.
It is the basis of their appraisal, yes.
If we go on to page 4, we see that the then Section 106 planning obligations relating to the previous 137 dwelling scheme. Do you see that? At
Yes.
the foot of that page. If you go over to the top of page 5, that then amounted to 2.38 billion.
Yes.
And at present, subject to the, if I assume that there'll be a blue line through the NHS Trust contribution, just so we take out whatever the current figure is, $130,000. I think we are at about the total value set out in the Section 106. I haven't taken into account the 100,000 which was just mentioned for the dowry, but it's something in the region of 1.7 million, I think, including that 100,000. Is that your understanding?
I don't have a total in front of me. If you would like me to provide you with a total, I can go through the draft 106.
Well, let's. Yeah, I'm happy to go through that, but let's assume that that figure is broadly accurate, and I've been fair to you, all right? And if I haven't, we can do the maths later. Okay, it's not. So we then go to Appendix D of this document, please. Which is the viability appraisal. It's called the policy compliant appraisal for 124 dwellings. So,
yes.
So for the inspector's note, we're now looking at 124 dwellings. So when she turns over to the first page thereunder, she'll still see under the heading construction costs and construction, the last entry there is Section 106 contributions. That's still showing the old 2.4 million referred to in the CBRE figure, all right? Just to, but if we look at that, that's telling us what the sales valuation is on the basis of open market. If we look at revenue, the first item, open market dwellings, 29.3 odd million, residential discounted market sales, affordable housing, 4.5 odd million, total 33.9. Do you see that?
Yes.
Then we've got construction costs. If we go over to the total costs on this next page is some 27.7 million. We'll come back to that figure. And then the profit of some 6 million, which, if we look down at the performance measures, that is only giving an 18.10% profit on the gross development value. And that's why CBRE have their warning, yes?
Yes.
Yeah. Okay. Thank you. Just labour that just to help. We've been told that we've got the £100,000 dowry to remember, to bear in mind. We've also told by Mr. Eady last week that when I mentioned to him the pitches playing strategy 2015, that there it had said the cost of a pitch, a 3G pitch, was some, I think it was 965,000. He said that's gone up, and he gave us the figure of 1.2 million. Do you remember that?
For the provision of the pitch?
Yeah.
I don't recall that, but I have his business plan in front of me.
Yeah.
That would help.
Yeah, 1.2. If we just look to see, that was the provision, the pitch. If we look to see what the assumption by CBRE was for that, if we turn to bear with me. They had a figure of, actually it's in the Ryder Levitt Bucknell, they have a figure of 750,000, I think. which is on page 5 of 9. So this is within Appendix A to CD 260. Appendix A is what's called the order of cost estimate, prepared by Ryder Bucknell. Page 5 of 9, bottom right. Tell me when you're there, please.
Page 59.
Page 5 of 9. 5 of 9.
Sorry, which document are you now referring to?
This is CD 260.
Yep.
After the letter, then there are a series of appendices. I'm looking at Appendix. Appendix A has a residential sales market analysis data. Yeah. Then attached. Then Appendix B is the cost estimate by RLB.
Yes.
And within that, I'm sorry, I said Appendix A, it's Appendix B, page 5 of...
5 of 9.
5 of 9. It's Appendix A to that Appendix B. No, you have to go, sorry, if you go on beyond, go up to 10 of 11, then there's an Appendix A to that. Sorry, it's an Appendix A to Appendix B.
PDF page 25.
Thank you very much. You see under item 6 on the left, if we look at C.2.03, sundries, do you see that on the left-hand margin?
Yes.
Come down to item 6, £750,000 for 3G sports pitch, no details, inclusive of excavation, drainage, lighting, fencing, etc. Yeah?
Yes.
And just whilst we're at it, at item 5, the allowance for construction of sports pavilion, 302 square metres at £2,400 per square metre. I've noticed from the condition 8 that that's now a minimum of 350 square metres.
That's correct.
So you have another 48 square metres and about another 115,000 for that element over the assumption in this appraisal.
That's correct.
Okay. So just pausing there, if I'm right, my recollection is right, and 1.2 million was what Mr. Eady told us rather than the 750. Okay, that's 450. Then we've got the 100,000 dowry that we've been told about today, and then we've got the 115,000 extra, minimum extra for the pavilion. Yeah?
Yes.
Now, if the 2.4 million for the Section 106 has come down to, on my calculation, 1.783, assuming that no money is payable to the NHS Trust, the blue line, then that's it's pretty well the same conclusion. You've lost some, you've gained some. So what the advice, the current advice stands from CBRE, does it not, that the developer, or if it's St Philip's, if they decide to go ahead with this, it's to be at their risk, isn't it?
That's correct.
Yeah.
The critical element here is we are not talking, the relationship between St Philip's and Brandon Estates is not this isn't a Redrow or a Persimmon. There is a contractual relationship, an ownership relationship between those organisations.
Ownership is a...
Yes.
Yep.
So the details of which I can clarify for you.
All right. Okay, there's an ownership relationship. Therefore, the owner, in its broadest sense, it's the advice to that owner in its broadest sense is, if you wish to proceed, you do so at your own risk. Yep.
That's correct, based on the viability assessment from CBRE.
And just help me with this, and that was just last year. I think that's the most recent one. That's the only one in the...
It is.
And just help me with this. Could you find out, please, and let us know outside of the inquiry, whether the sales to the sale to the registered provider would be at a greater discount than the 75% assumed for discount market sales, a greater, equal, or lesser amount. I don't need to know, precisely, but if it's less than that, because obviously that affects the values if it happened to be, if, for example, you're giving a 30% discount, it is going to be less money coming in, and therefore there's more of a problem. Thank you. Thank you. I can leave that point. If we look at your Appendix 11, please. This is the Litchfield's document. I think this came forward, this was an earlier version of this submitted in 3.6, I think it was, but this, which was plainly, I think, in error in some respects, seemed to be referring to a different scheme. Do you recall that? That's no doubt why it's been amended. Is that right?
I think some of the
front sheet.
The front sheet was, yes.
Okay. No. But yeah, we don't need to spend time on that. But I just noticed that that it's been improved on the front sheet.
I think time passed by, so the assumptions that are included in the document that accompanies my proof has been updated to reflect those more up-to-date assumptions.
Yes. But for example, originally I think it was. If we look at the front page, this originally it was I think referring to temporary jobs over something like a 20-year build. So it looked as though it had been. I think. Just one thing, just looking at the construction benefits, 29.3 million, when we were looking at CD 260 a moment ago, which is obviously last year, that was 27.7 million for total construction, total costs, not just construction, but everything related to that. Are you, in terms of the relationship of 29.3 to the CD 260, is there a direct relationship, or are these assumptions made by Litchfields?
They are different assumptions made by Litchfield.
Yeah. And on the right-hand side, the 104 jobs, underneath is brackets, temporary jobs over the 4.25-year build period, and that's the assumption, 4.25 years to build.
Yes.
Okay. And before the owner can commence, the owner must submit and have approved not only the affordable housing scheme and, if desired, a discount market scheme, but must also submit and have approved the open space scheme. Yeah?
Yes.
Have full details of the sports pavilion approved, including the associated car park. That's planning condition 7. And the specification of the 3G pitch must also have been agreed.
Yes.
The owner must also carry out a full asbestos survey before he can start. She start, right?
Yes.
And a phase
already one in place.
Phase 2 geo-environmental contamination report.
Yes.
Okay. And a remedial scheme must have been agreed and carried out. So obviously that's still to come. In terms, please, of the 56% social rent rather than 86%, that split, do you remember the 10-year split, 56 social rent and 44 shared ownership, rather than 86-14, I think. what evidence, Ms Casey mentioned yesterday in the Affordable Housing Roundtable that it had been a figure simply put forward by the appellant. What evidence was there behind 56%?
The mix was discussed with providers.
With affordable housing provider, the same provider that you've mentioned?
There were discussions with a number of parties who were active in the local area.
A number of providers active in there. Yep. Yep. I'm asking to clarify because there's simply no evidence for the inquiry, so and I didn't want to take an unfair point, so thank you for that. And in terms of the market housing, again, the market housing mix, it's accepted that that's not what the SHMA had in mind. Obviously, one takes that as a starting point and then one looks to see the evidence if one is justified. But in terms of the market housing, what was the evidence for the conclusions on the number of bedrooms?
One of those matters is referenced is viability. So the viability assessment that you've just had reference to in terms of the mix was based on that viability.
So, just so I can be clear, CD 2.60, that those was it decided? Yes, I'm just trying to think. Those are the house types one sees referred to in the market evidence for the valuation of those house types. Is that
yes.
Right? Yeah. But in terms of the need for one bedroom, for example, one bedroom houses, are you saying that because that would reduce the value achievable and make it less viable, that's why one bedroom are not included?
Yes, in part, the viability, but clearly, as referenced and as agreed with the local planning authority, the nature of the area in which the appeal site is located typically is not appropriate for one-bedroom properties.
But could you help me as to why not?
Based on the demographic and the experience of other schemes that have gone before us.
In terms of the site, there's common ground that the finding that land is previously developed land would not automatically justify development on all that land. It's common ground in relation to the glossary of the MPPF. The local plan, as Mr. Carter said yesterday, the transport assessment addendum said that there should be full car parking standards because the site falls within the low access category.
Yes.
And it was common ground on that. And the bus timetable, although the transport assessment, the original one, CD 1.19, said that it was every half hour. In fact, that's not strictly accurate. It's more like hourly, isn't it?
Yes.
Okay. And it doesn't go late into the evening, does it?
It doesn't, no.
And at the weekends, I think certainly on Sunday, it's sort of, or maybe Saturday, it doesn't matter, but it comes up to sort of
As
once
a more
every
limited
couple of hours. Okay. And you don't disagree with the planning officer's view expressed in her report, at paragraph 4.5, that it's a less sustainable location?
I disagree with sustainability as a wider concept in terms of transport.
Yeah.
I agree, as the discussion that took place yesterday with Mr. Carter.
I appreciate, to help you, that sustainability, we can look at terms of access, we can look at terms of PDL. Yes. I'm talking about in what the officer was saying in terms of location, that's in terms of access.
In access terms, by means of transport other than by the private car, yes, I agree, it is lower on the spectrum of that policy requirement.
Yeah. And that's something that's got to be taken into account, obviously, before one grants permission for a pitch, a 3G pitch. You've got to take into account how people are going to get there.
It is part of a consideration, of one of many considerations in terms of the balance, if it was in isolation, the balance of the proposal versus the other elements that we considered against all the other policies, including policies in relation to transport.
Yes. And so far as the local plan is concerned, policy GP2, general policy 2, could we just turn that up, CD 8.2, please? And it's page 12, internal page 12 of CD 8.2. Tell me when you've got that, please.
Yes.
Yes, the green belt we can see is at the bottom rung of that settlement hierarchy, isn't it?
It's at the bottom of that table, yes.
Yes, and it's a sort of sequential 3.16 on page 13, the next page. 3.16 says the hierarchy in policy GP2 provides a clear sequential approach to the selection of locations for sustainable development through the life of the local plan. Yeah?
Yes, as a general principle.
Yeah, thank you. And just turning on to GP3, previously developed land, the Council supports the redevelopment of previously developed land where proposals are compliant with the policies within this local plan. Yeah? So it's not an automatic support, it's got to be compliant with the other policies as well.
Yes, that's what GP3 says.
Thank you. And paragraph 3.9, going back to page 12, please. It says development away from the defined settlements of the borough is unlikely to meet all of the elements of sustainable development, particularly access to range of facilities. We've talked about accessibility. It then says that the last sentence, in some cases, it is essential for development to be located in the countryside, and where this is demonstrated to be the case, proposals will be supported. In this case, there's no suggestion it's essential for this development to be located in the countryside. No requirement, not essential for housing to be in the countryside, is it?
No.
No.
But the first sentence of 3.9 does talk about it being unlikely to meet all the elements of sustainable development.
Yes.
Particularly access to a range of facilities. So that was my earlier point of sustainability in the broader sense.
No, I'm asking about the last sentence. In some cases, just applying the last sentence, in some cases it's essential for development located in countryside. I'm just saying this isn't that case. You may have other policy points, but that's not something you're relying on in this case to say it's essential for there to be residential development in the countryside, are you?
No.
No. Okay. Just help me with this, please. There was public art reference in the design and access statement, I think the revised one, but as I understand it, that's now been removed from the illustrative landscape plan. Is that right?
Yes.
Okay. And that public art, I think there's a photograph, I can't remember the page, it's in the design and access, second one, I think, with the speedway rider.
That's correct.
With the shape of the
correct.
handlebars in the usual way.
Yes.
I don't think I'll ever experience that, but I can appreciate. I know I haven't. I'm looking forward to it in the next 60 years. Thank you. I probably won't know what it means then. So no public art. So if I go there in 5 years' time or 10 years' time, there won't be anything which gives me any clue that this had on the site, that there was an association. It's previous use. We've lost all that historical significance, haven't we?
The landscape matters are reserved, and therefore there is the prospect that elements of the landscape strategy could reference that.
Landscape strategy, you're including public art and landscape?
No, but landscaping. The reference within the landscaping.
What to how are you going to put? What is this going to be a sort of trimming a hedge to look like a
bushes? Yeah,
bushes. What to make them look like speedway riders?
Potentially.
I see.
There is an opportunity to influence the reserve matters, to reference place.
But in terms of the inspector can note that although it's in the design and access statement, because we have to be careful because the proposed conditions are saying you've got to be in accordance with the design and access statement.
Yeah.
In fact, I think at present, I may have been mistaken, it says you've got to be in accordance with both design and access statements.
Yes. Come
back to that. But anyone looking at that thinking design and access statement, we're going to get public art in that form of that.
Yes.
There's nothing in the 106 which is actually going to secure that, is there?
Not at present, no.
Oh. Are you proposing to include it? No, okay, not at present. Okay. Yes. If we could look at just please at 8.1 policy and the Greenbelt policy, just a point I wanted to take up with you in terms of any future requirement for planning permission. Not going to, obviously my learned friend Mr. Richards has put forward various points. And I think in your evidence you refer to paragraph 149B, is that right?
Take me to where I refer that.
Yeah, well, if I say someone your evidence,
I'll take your word for it.
Okay, it's a long time finding it. And anyway, but just to draw to your attention, 149D, the replacement of a building is an exception, a permissible exception, provided the new building is in the same use and not materially larger than the one it replaces. Yeah, that's be a relevant issue to be considered alongside the other parts of that policy.
Yeah,
yes,
the Greenbelt element, yes.
Yeah. And in terms of the past use of the site, we're not aware that there's been any statutory nuisance action that's ever been needed to be taken or taken by the local authority, environmental health officers, in relation to the stadium. Are you suggesting there is?
There have been a number of complaints registered.
In terms of an abatement notice, well, like, dare I say it, a community protection notice, but in terms of complaints, have you actually seen something official come out saying you've got to improve this, that, or the other?
I've not seen that. We have a register, a list in my proof of evidence of the complaints received by the authority.
Yes, we've seen that. We can make submissions on it because you can only, you're already simply setting out what you've been given there. Okay. Help me with this. Are you familiar with compulsory purchase principles?
I am, yes.
Yeah. And existing use value?
Yes.
Yes. So that if it's clear from the decision letter, for example, that housing development would not be permissible on this site.
Yes.
Right? Taking that just as a hypothesis for this proposal, not in any way assuming anything, then one looks to see what is the existing use value of this, and clearly its use as a stadium is a contender for being part of that existing use value. Yeah?
Yes.
And when one comes to value that, one's also going to take into account that it's in a state where money's got to be spent on the same to bring it back into use.
Yes.
So the existing use value of the land might end up by being nil or a minus figure.
That's a possibility, yes.
Thank you.
But as discussed with Mr. Stevens yesterday, there are no plans in place in relation to the CPO.
Well, but with great respect, why should the local authority call a meeting to say, before they know the outcome of this appeal, we're going to compulsory, why have a report looking into compulsory purchase, spending public money, doing all the due diligence that goes into that district value? Why spend that until one knows the outcome of this decision?
But they had their own, their motion that we talked about earlier with Mr. Richards was, we take from that, that's the start of what they were looking to do at that moment in time.
Yeah, it's explore the options.
Yes.
One option might be, depending on the outcome of this appeal and depending upon the attitude of the owner globally, one option might be that they have to give consideration to whether or not they need to compulsory acquire, whether it's in the public interest, etc., etc.
Exactly.
Yeah.
I agree. That is one avenue available to them. We are not aware of any strategy. There is no plan in place. No moves have been made in relation to CPO.
Yeah.
So, but you are correct. That is something that they could explore.
Yeah, thank you. Thank you. And it's not unreasonable for them to await the outcome of the appeal before taking time, giving consideration to something.
I agree,
Yeah.
but by the same token, the purpose of the motion last year seems to have fizzled out.
Well,
and was that not the intention?
Well, with respect to resolve that there's a compelling case in the public interest to compulsory acquire a site when you don't know whether it's going to get planning permission for some development which is going to go ahead and there won't be any option. It comes to the rationality or lawfulness of that decision as that's a compelling case to decide now to acquire it.
I agree, but on the basis that there appears to have been no preparation in advance of any progression in relation to a CPO indicates that it's not a serious contention.
Okay. Coming on to other points, floodlighting. As I understand it, there's a specific reference to floodlighting I don't find in the description of the application, or is that meant to be within the word infrastructure?
I believe it is within infrastructure.
Yeah, but just so that we're clear, because when we get on to conditions later, effectively the proposed condition, obviously it's draft, but that's assuming that it can be built. It's just the only issue is the details of it. And,
Yes.
okay, just to, I hope, just to assist the inspector in that regard. I'm sure she's well ahead of me, but I just flagged that up. If I could, bear with me a moment, please. Access to this site. Yes, in on the 25th, sorry, the 10th of August of this year, you sent a letter to Mr. Carter and Mr. Davis behind, Ms. Casey behind for the local authority, Mr. Bergwin, and indeed I'm on the email list as well. There may be others, but I can't see all of them. And it says there to Mr. Davis, there's been some correspondence, email correspondence about access to the site and who's coming on a site visit. It says, to be clear, the access is being granted in respect of your role in the forthcoming appeal. It is not in relation to your planning application, so no survey activity or similar associated with that is permitted.
Yes.
Mr. Humphreys, is this in the core documents list?
No, it's not, madam.
Because it's not something I've seen, I don't think, is it?
No, I've got to, it's only an email because it points only come up since this witness started. I'm just asking him about an email he wrote.
It's not something I've seen and I'm aware of, that's the point.
No, I don't think you are, but madam, it was said either under cross-examination or in chief that, well, the SCS haven't been on site, haven't carried out a survey they could have done, and I'm happy to get this copied. I can't copy the email at the moment, it's only online. We've been tracing back through, but I've given the date so the witness can check on it, and we can provide a copy of that when we've got access to a printer to print it off. But I don't think it's unreasonable to ask, there's no other way. It's directly this person actually wrote the email, I'm able to ask some questions about it.
Yes, but with respect, what we're doing here today is examining the appellant's evidence, and that isn't in his evidence.
No, I'm very sorry, madam. If a witness gives evidence, which isn't in his evidence, that they've allowed us opportunities to come on the site to survey, if I'm not allowed to say, look, this is some watertight box, I'm not allowed to bring in any evidence, frankly, that shouldn't have been allowed in the first place. It cannot be right, madam. I'm very sorry, madam.
I'll let you continue then, Mr. Humphreys, but
Yeah.
we don't need to
madam,
prolong this debate. But on this particular point, then, okay, you can continue.
Well, can I just... The way that is being contended is that this witness has said that the SCS could come on the site for any other purpose. That's not what Mr. Hooper said earlier. So I think we have to be very cautious and careful about what the chronology is. Mr. Hooper's evidence was very careful and very clear about that, about the extent to which there had been a request to go on site. What was being advanced in respect of this letter is saying, insofar as you are coming on site for these purposes, it is not for wider purposes. That is effectively providing the scope in which that exercise, which is to have a site inspection referable to the appeal, will be undertaken. Put shortly, the ground rules for that. What Mr. Hooper said was that there had been no request by SCS in order to carry out a survey for other purposes. That is essentially the gist of it. So the idea that these two are simply and happily elided by reason of Learned Friend's approach to questioning is, with respect, misconceived.
Mr. Humphreys, do you still intend to continue this line?
Because my clients, as you know, have not had an opportunity to go on site. We got the structural survey with the evidence, only with the evidence 5 weeks ago. That's the first time we had been provided with it. It wasn't given in advance, even though, as you'll have seen diligently, the survey was carried out, I think, in April. The costs were, costs Appendix 4 was something like July of this year. It wasn't provided in advance. The first time we saw this material at all was on exchange. We wanted to go on, my clients wanted to go on the site, and indeed, going back, I will just make this point, if I may. Could I just hand round a letter? If you take three, one for the witness.
Sorry, what letter are we handing out now? Sorry, Mr. Humphreys.
This is referring to, again, Mr. Hooper referred to a planning application which we'd made last year, and that we had when we had sorry, bear with me. We were told then that we had no legal right to access the site to undertake surveys and assessments, and that permission would not be forthcoming to access the site. So there's only one letter back in May of last year, but it provides the context for this recent position, as set out in the email, that we haven't had any, asked them for points, we haven't had any opportunity to carry out a survey. Last year, in respect to our planning application, no, you can't. You're not going to be allowed access. This year, you can only come on to look at the site. You can't come on to carry out the survey. That's the point.
Point, but I'm not going to allow further evidence and new letters to be submitted here and now that I haven't seen and Mr. Goatley hasn't seen either. Not in cross-examination.
Well, I'm cross-examining this witness now.
Yes, I know you are.
Yeah, and this is a letter written by DPP, by a colleague of Mr. Hooper's, junior colleague, in response to our planning application of last year. You've been looking at that planning application, the link, and I'm simply making the point, before it is said in closing, when it would be too late for me to come back because Mr. Goatley will have the last word, that I'm not happy for the impression to be created that somehow we could have gone on the site beforehand to carry out some structural survey. We've been precluded.
Just on the point you tried to make, I think you can maybe make it in a different way.
Mr. Hooper, last year when we had an application in, you on behalf of your clients objected to that application, put in a full objection to that, yes?
Correct.
And you made the point that your client's permission would be required for my clients to access the site, and that permission would not be forthcoming.
In relation to that planning application, that's correct.
And that was in relation also to undertake surveys and assessments.
In relation to that planning application.
Yeah. You say that was in relation to that planning application, and then this year, when we sought to come on, you said you can come on, but you can't carry out any surveys. So there was clearly an implied request there, wasn't there?
But to be clear, if we are going to go through this, I think taking a step back, initially, comment was made to the case officer from SCS that we were not permitting you access to the site. There had been no request in relation to this inquiry for you to access the site. Through Ella Casey, we contacted SCS to clarify the comment that we made about no access being granted was in relation to the planning application, and the response we got from SCS was they had taken our previous rejection of access in relation to that planning application as a no in relation to the inquiry. We were quite clear in going back to say, no, that is not the case. In relation to the inquiry, you were permitted to access the site.
But not for surveys?
Not for surveys in relation to your planning application.
Right. In relation to this, or your appeal now?
I cannot recall, I do not have the evidence in front of me to say what we said. My recollection is we said you are not allowed to undertake surveys in relation to your current planning application.
I'm asking you about this
I
appeal.
think we've had an answer here, Mr. Humphreys, and I'm not sure that Mr. Hooper's able to assist you any further.
Madam, I'm very sorry, madam, but he can, because he has the email on his own system. He wrote the email on the 10th of August, 11:59. Do you wish to have a quick look at that, please?
I'd like to have a quick look at it. I'd like to be provided with it, but not to you, Mum. So I understand what it is being said. This is not meant to be a rabbit out of hat. I mean, the inquiry's procedurals have been around for a very long time to provide for prior notification. Occasionally, documents need to come up. We understand that. And in those circumstances, it's provided at a time in which parties who need to have access to it can do so. So if need be, I can ask this witness about it in chief before he's cross-examined, not for it to be brought out Perry Mason style as an aha moment during cross-examination.
Not Perry Mason style. The evidence was only given after this witness started giving evidence.
This point has been raised before during the course of this inquiry and has effectively gone up there and has died on the vine. If this is a matter that was to be raised, this was a matter that needed to have been raised in advance.
I'm sorry, Mr. Humphreys, I don't think this is really going to help me in terms of my decision, ultimately. So I would ask you to move on, please.
We'll move on, madam, but I will make comments in closing on the list of what's been said. Just one matter which arose first thing this morning. You provided evidence that Mr. Eady had indicated. I think he gave evidence. I think it was Thursday of last week. Might have been Wednesday. Thursday of last week. The distances to St Finbarrs and Mount Nod. We didn't receive this outside of the inquiry, but can I just mention so the inspector knows it in case she gets anything further from us? We'd like to agree the distances, seek to agree the distances outside of the inquiry. We don't believe that these are the road, that we've given the road distances, but can we clarify that outside of the inquiry? if that's all right with you, Madam.
I want to be clear whether they are direct distances or road distances, as a crow flies, or road distance. Is that what you're saying?
Well, yes. Well, first of all, Mr. Hooper, do you know whether they're crow flies or road distances?
The note I have is silent on that matter. It just refers to miles and minutes. So I can't provide that clarification, but we can seek that.
Well, Madam, if subject to your agreement, please, I'd like to deal with that outside of the inquiry so we can present something. Is that all right? Thank you. Just bear there. Yes, I think there's one more issue, please. You referred in evidence in chief to Mr. Carter having referred to figures for participants in speedway and stock cars at Brandon. Remember that? And you referred to CD 1016, paragraph 5.13. I don't ask you to turn it up, but that's just the reference to the inspector.
Yes.
Because that was the reference that Mr. Carter had given to the inquiry.
Yes.
When the inspector had asked in relation to that. But just so I can be clear, when you came to write your evidence, had you read through all the objections that should be written?
Yes.
Yeah. Okay. So you were aware of that evidence, but you didn't respond to that. No one on your team responded. Mr. Eady didn't respond to it either.
In respect of the one comment on 2016?
In terms of participants?
In 2016?
Yes, in terms of 2016.
So there was just the 1 year that was provided?
Yeah. You didn't respond. Mr. Eady seemed to be unaware of that. He said there was no evidence at all. There are a number of points, which I've made repeatedly through this inquiry, where you have not responded at all. Your team, not responded at all to points already raised perhaps 2 years ago on this application, all in the CD documents. It's there, but never actually responded to.
No.
Is there a particular reason for that? Why didn't you respond? I mean, why didn't you ask your team to respond to them?
Respond to objections that were received?
Respond to the points made.
To the local planning authority or to those objectors?
Well, in your evidence, you knew the SCS were a Rule 6 party.
Yes.
You knew they had made a number of points correcting, saying that the mistakes made by Mr. Eady in his reports, updated, still not changed.
Yeah.
Why weren't they? Is it just too busy to look at it, or not aware, or just what is the reason?
No, I think the figure that you were drawing on 1 year, the figure, and yes, I accept.
Yeah.
Reference should have been made to that 1 year.
Yeah.
But in the scheme of the case and the evidence that KK Keeper were looking at, having reference to a single year in operation at Brandon Stadium.
Yeah. But it's not just that point, it's all the other points I had to take up with Mr. Eady. It's as though it blanked out.
Yes, I think Mr. Eady accepted that there were some minor errors in his report.
Okay. Thank you very much. Thank you, Madam.
Right, thank you, Mr. Humphreys. Bearing in mind the time we are, I know you've been there quite a while, Mr. Hooper, so is that okay to have a short break? Clearly you are still in your position, but we'll just have a short break then for 15 minutes till 4 o'clock. Thank you. And then we'll have your re-examination by Mr. Goatley. Thank you. Right, thank you everybody. It's just about 4 o'clock. So we'll continue then. Mr. Goatley, any points of re-examination, please?
Thank you. Mr. Hooper, small number of questions, please, in re-examination. You were asked about Mr. Morris and his evidence, and that him being Mr. Speedway for the purposes of this inquiry. You identify that he was not a stadium owner or operator. In your view, what, if anything, turns on, or what is the consequence of him not being a stadium operator or owner?
Very simply, the experience, the knowledge to operate successfully a stadium, which goes above and beyond that of being a rider, of which clearly he is very proficient, or a person who is responsible as a governing body. That goes to the heart of the challenge, as we put it, in relation to the costs that SES have put forward, on the basis that that is based on their knowledge as Speedway enthusiasts, and they have drawn on others around the country on that basis, but without that inside knowledge of the cost of insurance, in terms of lighting, everything that goes with actually operating a stadium.
Thank you very much. Now, you were also asked regarding the information available to KKP and some of the limitations on the data available to KKP. Your view, please, for the purposes of your view on the assessment of that data by KKP. Was the data that was available to them sufficient for the purposes of carrying out an assessment in order to support a paragraph 99A supported application?
Yes, they have based their assessment on the available information.
Thank you very much. You were asked by my learned friend Mr. Humphreys regarding various matters that would need to be undertaken prior to development commencing.
Yes.
Matters which essentially, as I understand from your answer, related to the conditions that would need to be discharged. Some of those relate to surveys.
Yes.
And in respect of some of those surveys, you appeared to commence an answer, but I don't have an answer as to whether or not any of those surveys have been undertaken now, albeit discharge of condition would still need to occur.
Yes, some of the surveys referenced have been undertaken, particularly in relation to the existing buildings.
To clarify exactly which ones we're referring to here, please.
Particularly asbestos. That's it as far as I'm aware.
Thank you very much. Yes, it's a short and discrete point, but can I take you to CD6, which is the officer's report? Do you have that?
I do.
Can you please go to PDF 46 of 176?
Yes, page 44.
The page number is 44 on the hard copy. That was the paragraph reference you were taken to about sustainability. Could you just read that for yourself?
Sorry, which paragraph?
Paragraph 4.5, I do beg your pardon.
Yes, I've read that.
What was the basis for that observation being made by the officer as to the site being a less sustainable location?
Simply its relationship when set against the settlement hierarchy.
Did that observation extend to any other aspects relating to its locational credentials?
No.
If I can take you, please, to the local plan, which is CD 8.2.
I have that.
It was in context of... Bear with me. GP3.
Yes, I have that.
And it was context of GP3 as to how that would work in context of previously developed land. Contention that land that is contained in the countryside is not land favoured for these purposes. And in paragraph 3.9, whether or not it's essential for development to be located in the countryside. If you have a site which is previously developed and in the countryside, in order to make effective and efficient use of that site, where would you need to carry out that development?
What, on the site in question, in relation to...
And what would be the characteristics of that site in terms of its urban or other characteristics?
In this respect, whilst it, from a planning perspective, sits outside the settlement boundary, as discussed last week, the characteristics were not of that nature. It is not open countryside.
Thank you very much. Thank you very much indeed, Mr. Hooper. No further questions. Thank you, Ma'am.
Right, thank you, Mr. Goatley. Thank you, Mr. Hooper.
Thank you.
May go and relax somewhere now. Okay, so next on our agenda we have two speakers. We have Mr. Sexton and we have Mr. Ford. I don't think we're going to have time for our condition session today, so I don't intend to do that, and we have time anyway. with other additional days, so I'm not going to address that. Who are we taking first? Do we have any preferences here?
We'll take Mr. Ford first.
Yep. Is that okay, Mr. Sexton? You okay for time?
Yes, I am, ma'am. Yeah.
Right, okay, thank you. So Mr. Ford then, please. First of all, Mr. Ford, thank you for coming back to see us. It's very much appreciated. It was unfortunate we didn't have time for you last week, but it is very much appreciated that you made the effort to come along today. Thank you.
Thank you very much. If I suppose you feel you're an hour ahead in France.
Yes.
All right. You tell us you're Cecil Matthew Ford, but known as Matt Ford.
That's right.
Company director. You refer to the stadium, Wimborne Road, Poole, Dorset. That's where the Speedway Stadium is. But you're presently living in France during the closed season.
During the season also.
During the season as well.
Yeah.
Could you please just begin reading from paragraph 1? I'll just let you.
Of course.
Read that through, please.
Hopefully everyone can hear me. I am, through my company, Poole Speedway Limited, the promoter of Poole Speedway, which has raced at the stadium in Dorset since 1948. At various times I have been a director of British Speedway Promoters Limited, formerly known as the British Speedway Promoters Association, the Speedway national governing body. I make this statement to oppose this appeal, the facts of which I refer to within my knowledge, unless otherwise stated, in which case I believe them to be true. I have run Poole Speedway successfully for 24 years. My team has been the most successful Speedway team in recent history, having won its respective league championship on 10 occasions in that time. During my time within the sport, I have regularly served on the national governing body and believe I have the knowledge and experience required to return Speedway to Coventry and run it successfully. In my view, Coventry Stadium was one of the very best for Speedway in the UK. I also believe that Coventry Speedway has a history and potential, attendance-wise, greater than my own club, Poole. I'd be thrilled at returning one of the greats to the sport, and the prospect of returning Speedway to Coventry and leaving a legacy fills me with excitement. On the 25th of May 2023, I spoke to Rob Godfrey, chairman of the national governing body of British Speedway, to advise him of my interest in returning and running Speedway at Coventry. He said that he would be delighted at my objective and confirmed that the national governing body would welcome the return of Speedway to Coventry. I have the experience to run all aspects of a Speedway team. I know what income can be projected and all the costs and the business liabilities. Under my management, Poole Speedway has traded profitably. No money has been borrowed, there has never been an overdraft, and the business has no debt. Poole Speedway stands on its own 2 feet. My intention would be to run Coventry in the same way that I would run Poole, and I believe that I have the experience to do so. One practical example in relation to the requirement for Speedway tracks to be licensed to ensure that they meet all relevant rider and spectator health and safety features. I have taken all steps necessary to ensure that Poole Speedway track satisfied and relevant regulations and was licensed throughout my 24 years of management. I also have the necessary means to run Speedway at Coventry Stadium. For example, my company holds some contracts, registrations also, of a significant number of riders. These contracts would enable me to assemble a competitive team at Coventry if the promotional rights were acquired. I attended approximately over 50 Speedway events at Coventry between 1990 and 2016, Whilst I have not visited Coventry Stadium since its closure in 2016, I recall its layout and features. I'm also aware that substantial damage has occurred. I believe that Speedway can be restored and successfully operated without using the grandstand, and that it would be viable financially to recommence use of the track, even though the stand themselves, as opposed to the terracing around the track, would not be able to be used at first.
Just pausing there, and I'm sorry to interrupt, but you're not giving evidence, not purporting to give evidence as a structural engineer. You're speaking as a Speedway promoter.
Categorically not. I have no knowledge of anything structural whatsoever. I am aware, through my experience of promoting Speedway, of a number of spectators who can reasonably be expected to attend this well-known venue. I believe that the same number of spectators that attend Poole Speedway would attend Coventry Speedway. The size and shape of the track itself means that there is plenty of space for spectators to stand on the terraces. The appropriate ticket pricing at current rates would be between £20 and £22, which with likely levels of sponsorship would be sufficient to pay a fair rent for use of the stadium, pay all of the business costs and expenses, and operate Speedway at Coventry profitably. As a former director of British Speedway Promoters Limited, and from my recent conversation with its chairman, I do not believe that there would be any issue preventing the national governing body from licensing Coventry Stadium for Speedway without the use of the grandstand.
Thank you. Just a few questions, if I may. Mr. Ford, Mr. Osborne is your immediate landlord at Poole, is that right?
He is.
Yes. So there's I think the council own the stadium. They lease it to Mr. Osborne, and he subleases to you. That
is correct. Yeah.
And you have a lease, do you, with him, or some sort of arrangement?
Yes, we do. We do. It's private, but a lease was signed last year with a break clause.
Break clause. Okay. And you say in paragraph 11, I'm aware through my experience of promoting Speedway of the number of spectators who can reasonably be expected to attend this well-known venue. What sort of number have you got in mind in terms of your experience promoting?
The level of enthusiasm for Coventry, should it have been as it was, with capacity of 12,000, I don't think it would have been difficult to have achieved a capacity crowd in the initial period of reopening. That said, to run the business successfully, you would need in the region of 12 to 1,500 paying spectators, along with obviously a substantial amount of sponsorship as we achieve at Poole.
Yes, if we could you take up, please? You give you provided a rebuttal statement. I don't ask you to read all of that out, but you refer in paragraph 2 to the nominal profit and loss that Mr. Osborne produced as effectively an appendix to his evidence. It's in the core documents, where he makes various suggestions about the accounts, financing and viability of Speedway. And I'd like you to turn those up, if you could. So that's, Madam, that's CD 15.5.57.
Yes, I have Mr. Osborne's attendance figures and etc.
Thank you. And in terms of, you've said that you don't think the figures are accurate. Could you just explain what you've got in mind in general terms, please?
The figures are based on figures that were that Clark asked Steve Park, who was a promoter at Swindon Speedway to put something together. It wasn't for obviously to be used in any respect other than it was believed it was for and on behalf of Swindon reopening. The figures that Swindon achieve are slightly lower than my own pool. In particular, certain things that I would pick. Things like sponsorship. It shows a figure here. Do I talk about this, Richard? Or
Yes,
okay.
please.
It shows a figure here of £600 a week, based on 17 meetings at 10,200.
Just pausing there to help the inspector, which column are you referring to here?
This is sponsorship local. It says it's down from the concessions and the
Yes.
It says meeting and annual.
And
And
the 600, that's in the championship column. We've got three columns: Premiership, Championship, NDL.
Beg your pardon, Richard. The one that I've got currently here is Clark's championship figure. So in his championship figure, he has a sponsorship local of £600.
Yeah.
10,200 over a season, whereas I would expect to be bringing in projected figures of 4,500 to 5,000 a week. So if you were 17 meetings, it would be between 76,000 and 85,000 a year. For 17 meetings. If I take this year's figure, we brought in 98,000.
And just help me, we've got these, if we look down, we've got the Premiership, the Championship and the NDL in those three columns. If we look all the way to the bottom, the estimated profit and loss, Mr. Osborne is saying, yes, there will be a profit for Premiership and a profit for NDL. You're looking at the Championship and taking, so if one looked at the sponsorship, instead of 10,200, you say it would be substantially more than that. Is that right?
That's right.
And that would therefore make that minus 323,750 at the bottom a positive figure.
That plus other things. This is an incredibly loose profit and loss, of course. There's as many things missed off of it as there are stated on it. If those were the only bills that the Speedway promoter paid, he would be over the moon. There's several other things that he has to pay, but also there's the income levels have been projected very low.
In terms, you've mentioned sponsorship. Is there any other sort of headline figure or figures?
Let me see. Merchandising. The merchandising it shows a £475, showing an annual turnover of about 8,075. My declared figures this year are 39,000. It's not sales are not just taken from a track shop on the day of the event, but the club, obviously, all of the professional clubs now will have online sales, which are now some larger fees, larger profits.
Okay. And just so that I can be clear, if you brought back Coventry Bees, would that be in the championship? Is that the first stage that you have in mind?
That's right. It'd be the first stage because I've ran in the top level of the sport in Premiership Speedway until 2019. Of course, we then had COVID, and when I came back at championship level. And the primary reason for me moving leagues, it's 90% of the reason I moved league, was that to honour the television contract, the Speedway has to be raced on a Monday and a Thursday. My club has ran for 75 years on a Wednesday. Changing people's habits after such a long period of time is just impossible. And it didn't work. In the 2019 was the only, beg your pardon, was the only season that in the last 20 years that the club lost money, and that was due to the fact that my gate receipt was down about 22%.
Okay. And since COVID, in terms of your gates, have they gone up, gone down, or stay the same?
No, very good now. We've just had, obviously, when we came back from the initial COVID issues, there were restrictions on crowds, as there were in all sports. So all stadium had the same problem. So 2020 was lost entirely. 2021 we didn't start until we had one meeting in June, and then myself and a representative of the stadium, a senior representative, decided to delay for a further 3 weeks because the restrictions imposed by the government were just too restricting. So we had to delay a further 3 weeks. So effectively, Speedway runs, it says here from March to September. Last year I ran into November. That shouldn't ever happen. It should always be finished by October. But if you're successful, you will always be riding in October. So my club's riding tonight. If we qualify, which we should, I'm hoping, that for the final of this event, that will be on either the 4th or 6th of October, and I still have 2 more cup finals to run.
Yeah. In terms of looking under the championship column, if you came back to Coventry Bees, would you be are you aspiring to the Premiership thereafter, or is it just stay in the Championship?
No, absolutely. Speedway, at times, you should not run before you walk, and you need to see how the business is running before you overcommit it, as in any other sport or any other business, and that's exactly how I would feel comfortable to bring the sport back at that level, should it be successful, the appeal, this be successful.
Sorry, Karen.
Beg your pardon. And so that would be the first part. Thereafter, I would hope that Coventry would take its rightful place at the top level of the sport.
In terms of the figures there at the top of that middle column for Championship, you have assumptions, Mr. Osborne said assumptions average adults 600, concession 400, children 100, so that's 1,100. Is that right? Is that, in terms of the figures, you said in pool, that might be a bit below what they're doing at Swindon?
Yes, it's below what I achieve at pool, but more importantly, whilst every track has to be taken independently, there is, of course, a success story at Oxford just 2 years ago. They have put their own self-restriction on their crowds. They initially applied for 1,500. I believe that was raised then because they were achieving anywhere between 1,600 and 2,000 people a week. And they've now asked for that to be increased to nearly 3,500.
To nearly 3,500.
3,500 now, yeah.
And in terms of, just remind me of the figures for pool. You say they're above your average figures over a season. You say they're above the 1,100 that we're seeing at Swindon for Championship. What sort of figures?
Yeah, I mentioned that we do very well in sponsorship, and so in sponsorship, I would normally a package would include tickets for sponsors to attend. So those would be in that package. They wouldn't necessarily be paying to gain admission to the stadium, but I would put our trading figures in the region of 200 above the figures quoted here. Pardon, I would put the trading, adult concession children figures to be in the region of about 200 people more than those shown on the Championship level on this document.
So just as I understand it, you said 1,100, obviously that's shown on Championship, 200 more, it's about 1,300.
Yeah, I would say. Of course, Richard, as in any sport, the more successful you are, the larger the crowds become. So.
help me with this. In terms of the health or otherwise of Speedway, how would you, from your experience, how would you describe that health or otherwise of Speedway?
I've been promoting since I had a partner at Poole Speedway in 1999, which was the first time that either one of us had promoted Speedway. We had a helping hand, someone that had promoted for 20 years who stayed with us when we took the club over, which is crucial. And in my time in the 20 years I've been there, I can't say it's either improved greatly, if I'm honest, or has it been hit badly. My crowds have stayed fairly level. You could have a certain rider that would attract more people, and he may bring an extra 300, 400 people. And that's certainly happened in my time. And we've been successful. We've been successful on track. That helps to be successful off of it. And it's always ran, and as mentioned in my statement, it's ran on its own 2 feet. We've never had to borrow a penny. And in the state of the sport itself, I think as any sport can be questioned, whether it be football or rugby, and at the top level, 13 clubs going to 10 in just the last 3 years. We're doing okay. We're holding our own. There's of course mismanagement. I will say that at times by promoters, managers, not managers, but promoters, owners of club. And in all honesty, perhaps the restrictions to become a Speedway promoter should be a little more stringent, but because that's where we fall down. So if it's ran by old hands and people that know what they're doing, just as Mr. Van Straten said a couple of days ago, who's ran for 35 years, it will run successfully.
In terms of paying rent, just to give a feel, in terms of, do you have to, sometimes you're not able to pay rent to Mr. Osborne on time, or are you, because of financial difficulties?
To the contrary, I always speak to my landlords to chase them to invoice me. I pay in advance. I'm in credit now. I'm always in credit during the course of a season. So I've never once caused my landlord an issue for payment.
Yeah. And just going back to the notional operating profit and loss account or data, that's headed Speedway, notional operating profit and loss data. You've said there are a number of issues you have with the figures provided, and also you're not sure it's complete either. But in terms of stock car racing, does it make any allowance for sharing of costs, for example?
Nothing that I've put down, no, nothing at all, because with the greatest respect, I've never promoted stocks and I know very little about it. I truly am only a Speedway promoter.
Thank you very much, Mr. Ford. If you just wait there, Mr. Goatley may have some questions.
Okay, yes, thank you. Thank you, Mr. Ford. Mr. Goatley, yes, do you have any questions?
Indeed, Mr. Ford, good afternoon.
Good afternoon.
Mr. Ford, first off, if I may, I'm instructed that it's your son who actually runs Poole Speedway now, because you're predominantly resident in France. Is that fair?
That is correct, yeah. I'm still 90% owner of the club, but he runs the day-to-day running of the event.
So, for the purposes of your involvement within Coventry, would that be your son, or would that be you, on the basis that your stated intention is that you would be involved in the same way that you run Poole Speedway, which is actually via him?
No, it's not via him. I still pay the bills. I still do all of the contracts. I still do any of the legal matters connected with the club. My son runs the day-to-day event of putting on the show. So I would intend to be, whilst I live in France now, that wouldn't necessarily be the case should this be successful.
How long have you been living in France? Don't mind me asking.
5 years. 4.5 years.
And it'd be fair to observe that during that time you've not sought to relocate in order to have a greater involvement in Speedway, particularly at Poole.
Pardon, just if you could
Yeah,
just explain.
during that 5-year period, it is fair to observe that you have not sought to relocate back to the UK in order to be able to have a greater involvement in running the Speedway at Poole.
No, because the club is running successfully in profits, just as I left it.
Now, you received, I take it, Mr. Osborne's evidence, including CD 15.5.57, the notional operating profit and loss, when evidence was submitted in five weeks ago.
Yes, I believe that's when I would have got it, yes.
Yeah. If there were material differences or difficulties with any of those figures, you'd have had the opportunity to put in an alternative operating profit and loss set of accounts, including, if need be, those that you operate at Poole. That's right, isn't it?
I wouldn't have known I would have had that option to do that. I'm sorry, but I'm not a lawyer or a barrister. I would have no clue that would be possible.
Right. No one suggested that to you, because they did suggest to you, presumably, that you put in a rebuttal statement, which you did, which is your 16.2.10, which says that you reject the figures. You just don't tell anyone why. That's right, isn't it?
I reject the figures because they're inaccurate.
Yeah. You don't actually, in any respect in that written statement, identify any of the figures which you consider to be inaccurate. That's correct.
On the statement you're talking about, it's very quick, and no, it doesn't question the figures. Mm. It just says that I believe them inaccurate.
Now, do you have any responsibility for running the stadium itself at Poole?
Absolutely not. No, that's run totally by Gaming International, and I'm their tenant.
Do you have any experience of running a stadium?
No, definitely don't. No, not at all. I'm a Speedway promoter.
Have you had any experience yourself in the site licensing of the stadium, particularly by reference to matters involving health and safety?
Not on behalf of the stadium, no, only for the Speedway purposes through my association.
In respect of the holding of contracts for riders at Poole Speedway, how do you say that will assist in context of Coventry Stadium?
The riders that are effectively owned by clubs, the retained list of riders that I have is large. It would be the largest in the sport. Over the years, I've invested in purchasing different riders from other clubs, and so I would have a much larger list to choose from than many others.
Just for my information, as I'm no expert in this, but
No.
what sort of number are we talking about here?
I think my retained list is about 30 currently, and you need 7 to run a team.
Now, those contracts, those allow you to seek to utilise those riders unless those riders are presumably riding for someone else.
I have first call on all of them. In Speedway, you retain their licence, so every person that I would loan riders out to other clubs and seek a fee for doing so, but I would have first call on those riders before anybody else.
With regard to your existing team, because you run the team at Poole Speedway, that could presumably result in that team being denuded of riders if you were to shift riders from Poole to Coventry. Would that be right?
Definitely wrong, no.
Well, what would be to prevent that if you actually have first call and you were utilising that for the purposes of potentially preferring Coventry over Poole?
I've certainly not said that, Mum, that I have any preference for one over the other. I do not know where that's come from. But I did just explain to you that I have 30 assets. You need 7 to be in the team.
Now, all of those still relate only to the issue of team, not the stadium, correct?
Absolutely.
What would be your involvement at Coventry? Would it be in context of the stadium or only in respect of the team?
No, purely as a speedway promoter. So as I do at Poole, exactly the same as I do at Poole, to be charged a fair rent and to put on an event. I would not have any form of profit and loss from catering, from bars, from car parks. That would all be down to Mr. Hunter.
So whoever the owner was?
Yes, that's exactly the same way that it runs with Gaming International now. I would have just be paying a rent for use of the stadium. And
what would be your rent that you would be paying for the use of the stadium? What do you anticipate for that?
We believe to the rent to be similar to that I'm paying at Poole Stadium, which I don't feel that I should disclose, but there's a very similar figure.
Well, what we know about Poole Stadium is that Poole Stadium is not a stadium that requires significant amount of new work by way of reinstatement, albeit it does require, presumably, ongoing maintenance and renewal in order for the stadium to continue in operation. Yes?
But I wouldn't be involved in those things at Coventry. That would be Mr. Hunter, who obviously has stated that would fall under his criteria, and not for the tenant.
Yeah. Well, it's not for the tenant. There's a large element of decorousness about this in terms of what would be the rent paid and what would that rent being paid to the stadium owner actually provide for, because the stadium owner has a number of costs of their own in terms of electricity, power, in terms of insurances, as well as anything relating to renewal or maintenance of the structure once it's back into any operating condition. That's right, isn't it?
That's why it's always included in my rent that there's an increase every single year, which is set by my landlords.
Right. And you don't feel at liberty to tell us what that rent is?
No, I think Mr. Osborne's here tomorrow. You're welcome to ask him, but I believe that to be his business.
Now, so far as the Coventry Stadium is concerned, you've kindly already told us that you have not been to visit it since its closure in 2016.
That's correct.
So you have no direct knowledge of the condition it's in, or how it can be restored, or what would be the position with regard to financial viability for its restoration.
I only, obviously I've seen photos of the damage caused and the terracing. I've obviously listened to my colleagues that have seen the stadium, but on a personal basis, as I made abundantly clear, I have no knowledge of structural damage nor the cost of those structural damage to repair.
So it would be fair to observe that you are unable to assist the inspector, that it would be financially viable to actually restore and operate the site.
I cannot answer anything structurally. I only know what would be achievable if Speedway was to return.
Now, you've taken issue with those notional operating profit and loss data figures. So far as Premiership and Championship are concerned, do you operate in both of those leagues?
I don't now. I used to be in the Premiership for 17 years, I think, maybe. No, 19 years, I believe. Then I mentioned to you earlier, or mentioned before, but due to the television contract changing, that we had to run on, to honour the contract, we had to run on a Monday and a Thursday, and my club always ran on a Wednesday. So I tried it for 1 year, and for the first time ever, lost money in Speedway, and made the decision to take my club to the league below, where I could return to my normal race day.
With regard to the figures that were obtained, I'm instructed that among the sources that Mr. Osborne went to was the current operator at Poole Speedway, your son, in order to obtain data. Does that accord with your understanding of the data that's involved at Poole?
No, I certainly don't know anything of that, so I'd be shocked. But I'm sure that at times I had a phone call myself from the manager of Poole Stadium about 3 weeks ago, asking if I'd be returning to the country shortly. That Clark would like to speak to me, and I said I would happily speak with Clark. I didn't realise at that point in time that we would perhaps be sitting a different side of the fence here.
So far as, because what it is fair to observe is that Mr. Osborne is a experienced stadium operator. Yes,
Absolutely.
Now, you also have suggested some figures for Oxford in terms of its attendances. None of those figures have been given by Oxford Speedway itself, because we've had certain communications to this inquiry, none of which have indicated any figure for attendance. Is there any publicly accessible figure that indicates any of the figures that you've identified?
No, just through a conversation with the promoter this week, Jamie Courtney, who I spoke to about a number of matters, not just regarding this, who told me exactly what his figures were. He checked with the owner of the club, Kevin, to make sure that he was happy for the figures to be disclosed, and he was more than happy. But written proof, only purely a message that would say that those figures are correct.
Because unlike certain other sporting events and occasions where the attendance figures are declared and declared publicly, these are not something which appear to arise either commonly or at all in context of Speedway.
That is true.
So in terms of being able to verify any of those figures, there is no means of doing so, is there?
Only that I spoke to the man direct that runs the club, and so I'm sat here to give evidence, and will do so to the best of my ability and in full honesty.
Have you been to Oxford yourself?
No, I haven't since it's returned. Obviously many times before, but not since it's returned.
So it would be fair to say you are relating, and I do not criticise you, you are relating what has been told to you, but we have no verified or verifiable figures for any of the attendances.
I think that's fair. That's fair, yes.
Have you made any assumptions as to what would be the licensed capacity at Coventry, both to start with and thereafter?
Again, it would be down to what permissions were given by the council once, I guess, the works were carried out to a satisfactory condition to allow people to use the terraces or the under the covered grandstand. But certainly from my perspective, 1,500 would more than cover its cost. And above that, I believe it would be hugely above that, would obviously make the club very profitable.
Yeah. If it were above that, then subject to whatever the gentleman at Oxford has told you, that would be substantially more than are attending generally in context of pool.
Yes, it would. I think there's no doubt about it that when clubs come back from having been away for 6 or 7 years, there's a certain amount of people that would attend. Certainly those that used to go, but I think it also would appeal to those that haven't been before, because it's obviously the television coverage and etc. would help that matter. So whilst I have absolutely no certainty, I believe that the figures would be far in excess of the 1,500 I would need to cover costs.
Was there an increase in attendance at Manchester after it reopened in its new stadium?
When it first opened, yes, there was. But I can't tell you the figures, but when it first opened, the figures were substantially better than when it left its Kirkmanshaw Lane site a year or two before.
Because we have heard of the difficulties at the Manchester Stadium and the ability of being able to viably run Speedway operation at Manchester Stadium. Have you heard that evidence?
I think the stadium wasn't designed solely for Speedway. It's designed for hockey also. It has several pitches in the centre. A large amount of money was committed to that project. I'm told £6.5 million, and the restrictions placed by Manchester Council in terms of security and etc. I think are probably far and above what the other Speedway clubs have to adhere to.
So far as TV coverage is concerned, is there any specific TV coverage for a particular site, or are you anticipating TV coverage of the sort to which Mr. Matthews has referred?
Sorry, I don't know who Mr. Matthews.
Okay, fair enough. No. I won't ask you. Morris, I beg your pardon. Mr. Morris.
I beg your pardon.
Thank you.
Yeah, no,
it's that time of the afternoon. I do beg your pardon.
Okay, no, I understand. No, Mr. The revenue that comes in, I believe, in its entirety is a 7-figure sum. I'm no longer in that league, so I don't benefit hugely from it. The only thing that the championship clubs benefit from is our office fees are covered. Office meaning the BSPA head office, that effectively, if you wanted a monetary figure on that, I would benefit to the tune of around about £12,000 a year. I don't receive the £12,000, but it pays all my fees that if that contract wasn't in place, I would have to pay.
And that's because you're in the championship?
That's right. The Premiership have a different level, much different.
Right. So far as TV coverage is concerned, it's pretty marginal as to the impact that it has with regard to revenues.
It would be for while it was in. If we're talking about Coventry, whilst it was in the Championship, it would be marginal.
Mr. Ford, thank you very much indeed.
Thank you.
Mr. Ford, just before you go,
yes.
I thought Mr. Gottlieb might extend his discussion onto this, but Mr. Morris, in his evidence, made reference to commercially viable streaming service that you operate at Poole.
It's the whole league now, ma'am. It's called British Speedway Network.
Right.
So the whole league is now being streamed. Normally, they will pick 1-2 clubs a week. Certainly, when you get to playoffs, they would increase that level. But yes, that is a building revenue and gaining popularity. It's still in its infancy. It's only 2 years old, but it's beginning to work very well.
Right, and the income from that goes to whom? The promoter of the stadium?
No, it's divided by the company that own it. They retain, I hope I'm not saying something I shouldn't say, but they retain 55%, and 45% comes into the clubs in the championship.
Right, that income, sorry, Mr. Gogan.
I just want to understand that 55% goes to whom?
It's the company that do the platform, they do all of the filming, they take all of the cost of putting the event on.
Thank you.
45% that goes to the clubs, that's to you as a promoter or to the stadium?
No, to the clubs, to the Speedway club.
Right, okay. All right, that's helpful. Thank you for that. So I don't think there's anything further from me. So thank you very much for your time. Sorry, yeah, you're right, absolutely. As you say, it's the end of the day. Yes, any further questions, Mr. Humphreys? Sorry.
Yeah, 2 points. When you said the money goes to the club, is that separate from the promoter?
Yes, absolutely. The club. None of us take anything.
No.
Yeah, personally.
So thank you. And the other thing, you mentioned Mr. Courtney at Oxford.
Yes.
Do you know him well?
Very. He's been a promoter. He currently owns 2 clubs in the same league. He owns Berwick and Oxford. And runs them both successfully. Both clubs are. Is
that Berwick and
Berwick? Yeah,
Berwick on Tweed.
Upon Tweed, I think it is.
Not Berwick in Sussex.
No, Berwick in near Scotland. Yes.
No. And just to be clear, have you any reason to doubt what Mr. Courtney told you? Was it?
No, absolutely not. I believe his credentials are what got him the position at Oxford. The fact that he knows what he's doing and he's runs a successful business in a very, very small town in Berwick. There's only, I believe, between 11 and 13,000 people live there. Yet he has attendances closing on 1,000 each week. So, which is if we could replicate that in any other town, it would be wonderful.
Thank you, Ms. Humphreys. So thank you very much, Mr. Ford.
Thank you very much.
Okay, so now we have got Mr. Sexton from Thurrock Hammers Speedway. So, Mr. Sexton, if you'd just like to come to the front there. Thank you. Now, we've all received a statement from yourself. So I don't know whether you wish to read it in its entirety or just to pick up certain points, but I'll leave that up to you. However you wish to present this afternoon. Thank you.
Yeah, good afternoon. With your permission, Ma'am, I'd like to read the complete statement on behalf of Thurrock Hammers Limited. I am Mark Sexton, a director of Thurrock Hammers Limited, whose registered office is at Belfield House, 104 New London Road, Chelmsford. We are a company incorporated in 2019 to restore Speedway in Thurrock. I've been involved in Speedway in some capacity or other for nearly 50 years. Although I was not involved in the day-to-day management, I was the community liaison officer for Lakeside Hammers from 2009 until its closure, and because the Lakeside Hammers ceased to trade as a result of the closure of the Arena Essex site by its current owner. My first visit to a Speedway meeting at Coventry Stadium was in May 1976. In the following years, until its closure in 2016, I attended numerous British finals, the National League Riders' Championship in 1987, and numerous other team events. I knew Coventry Stadium to be one of the finest Speedway venues in the United Kingdom. In his cross-examination of Mr. Allen, Mr. Goatley raised an issue which Mr. Allen was not able to answer or address. As a result, a false and misleading impression may have been created, which I am concerned will mislead the inspector, which I believe I'm in a position to rectify. Mr. Goatley suggested that the attempt to reinstate Speedway in Thurrock would be frustrated by the insolvency of Thurrock Council. This is not the case. In or around 2010, Grays Athletic Football Club, which is based in Thurrock, lost its ground to development. No replacement facilities were established. I've been informed by Councillor John Kent, a former leader of Thurrock Council, that the council then put in place specific policies, and I would refer the inspector to CSTP 9 and PMD 5 to protect sporting facilities following the loss of Grays Athletic Ground and to ensure that such a loss would not be repeated. Those policies were then applied in the case of Aveley Football Club, where the creation with associated facilities, including a 3G training pitch, was a condition of planning permission for residential development of its ground. The Speedway track is situated at the Arena Essex Raceway, which is a 125-acre site close to the Dartford Bridge and the M25 in Thurrock. The current owner's planning application is for 2,500 dwellings. Its proposed Section 106 budget is in excess of £29 million in money or money's worth. This is as published on the Thurrock Council planning application website and forms part of Appendix 1 of my submission. While the application of funds suggested by the site's current owner ignores Speedway and the national and local policies, our campaign seeks to ensure that part of this budget will be applied to satisfy the NPPF requirements and Thurrock Council's current policies to protect sporting facilities at risk as a result of proposed development. And our campaign has engaged with the planning and political processes to do so. As a result, and to reflect the policy, precedent, budget and substantial local, regional and national support, Thurrock Council unanimously passed a motion on the 25th of January 2023 to support the retention of Speedway in Thurrock. I believe you've had sight of that motion. Please correct me if I'm wrong. And the motion read, Thurrock Council resolves to use the local plan process to support the retention of Speedway in Thurrock and identify a new home for Grays Athletic in the town. At no time has any funding been sought from Thurrock Council, neither will any funding be sought in the future. At no time has any suggestion been made that Thurrock Council will construct or manage a new Speedway facility. Its insolvency will not interfere with the application of the NPPF, current council policies, or the Section 106 funds in question. On the contrary, the objective is, in addition to the preservation of the existing or the creation of new Speedway facilities, to use the planning process to ensure that part of the Section 106 budget is applied to create a Speedway facility with additional community benefit. Part of Mr. Eadie's evidence in chief have been inaccurate. I will address the relevant points to rectify them. Lakeside Hammers ceased to trade at the end of the 2018 season when the Arena Essex site was closed to all forms of motorsport by its current owner. There was no other track in Thurrock or in the wider Essex area on which Lakeside Hammers could race. At the request of John Cook, the promoter of Lakeside Hammers, who I'm sad to say has since died, I met a director of the current owner of the Arena Essex site, London Strategic Land Limited, on the 29th of November 2018 to ask for the site to be made available for use for Speedway. The request was refused. This decision brought to an end 35 years of Speedway on the Arena Essex site, during which time it was Thurrock's highest level and best attended team sporting activity, with average spectator attendances being significantly in excess of the borough's non-league football clubs. Speedway again found itself suffering from a lack of a stake in the ground, and a victim of the decision of a landowner, the land tenure issue which has been identified during this appeal hearing. In his evidence, Mr. Eadie referred to the company of which I'm a director, namely Thurrock Hammers Limited. He did so by suggesting that the Lakeside Hammers team moved to the Rye House Stadium and became Thurrock Hammers. This is not correct. Thurrock Hammers Limited had not been incorporated at the material time and has never raced at the Rye House Stadium. The arrangement for racing at Rye House in 2018 was because sufficient dates for Lakeside Hammers to complete its fixture obligations were not available at Arena Essex, another example of the land tenure problem. Mr. Eadie also failed to mention a key fact to put what he claimed to be the attendance figures between 2008 and 2017 in context. Lakeside Hammers competed in the Sky Sports Elite League, the highest tier of professional speedway in the UK, between 2008 and 2016. Lakeside Hammers competed in the National Development League in 2017. This is the semi-professional league in which the best riders do not compete and which typically attracts lower spectator numbers. In 2018, the Lakeside Hammers competed in the Championship, which is the second fully professional tier of British Speedway. I do not know the exact attendance figures, but I am aware from my work as the Community Liaison Officer and my regular track day attendances that the 2018 attendance figures were significantly higher than those reported by the landlord in 2017. This was not reflected in the evidence given by Mr. Eadie. What I do know is that over 3,000 spectators attended the final Lakeside Hammers meeting at the Arena Essex on the 14th of September 2018. That concludes my statement, Ma'am. Thank you very much.
Okay, thank you very much, Mr. Sexton. That's helpful. Mr. Goatley, is there anything you want to ask or address, Mr. Sexton?
2 points, if I may. Mr. Sexton, good afternoon.
Yes, good afternoon.
Mr. Sexton, with regard to you specifically name-check me, so I'm going to try to understand the position. Are you saying that what I asked was false or misleading?
I think there might be a danger of that, Mr. Goatley.
Right. Think very carefully about that, I would suggest, Mr. Sexton, before answering that question again. Are you saying that what I asked, and the question I asked of Mr. Allen, was false or misleading? The tape's available. I've looked at the tape. I've looked at the notes.
Yes,
the context in which it was asked, including what had been said in context here of the potential for, among other things, the West Midlands Mayor to potentially be a funding source, i.e. that there were potential public funding sources. That is the reason why the question was asked. Are you saying that was false and misleading to simply ask the question, Mr. Sexton?
If you are telling me that question was asked in good faith and was not intended to be false and misleading, I would accept that, absolutely.
Thank you very much. Ask, if I may, in respect of the Arena Essex site planning application.
Yes, sir.
As I understand it, there is what is suggested to be a planning obligation budget of some £29 million in money or money's worth, but that none of that is proposed to be directed to any form of speedway use. Is that correct?
That is correct, yeah.
Who would be the relevant party who would be disposing of any of that sum in the event that your entreaties to Thurrock Borough Council were successful?
We would, Thurrock Hammers Limited was created in 2019 with the view and ambition to return Speedway to Thurrock. We believe that we would be in the best place to deliver that for the
Who would be paying you the money? It would be Thurrock Council, by reference to the sum of money which had arisen from that planning application. Is that correct?
You referenced the numbers that has been suggested by the current owner in the planning application, as I understand it.
But
Of
what's in your-
£29 million.
That's
Yes.
what's in your statement, paragraph 7.
Yes, it is. I agree. Yes, yes. I mean, that's as evidenced by the.
But the people who get the money from would be Thurrock Council, wouldn't it?
I do not believe that to be the case, sir.
Right. Okay, well, I'm just going to leave that one there. Can I just understand, it may well be there's a misunderstanding. This is paragraphs 15 and 16 of your evidence. Racing, you say it's 16, the arrangement of racing at Rye House in 2018 was because sufficient dates for Lakeside Hammers to complete its fixture obligations were not available at Arena Essex. Do I take it from that Lakeside Hammers went to Rye House to complete their season?
Yes, that is entirely correct.
Right. So it would be right to say that Lakeside Hammers have themselves competed at Rye House Stadium.
That would be 100% correct, sir. Yeah.
Understand. Thank you very much indeed, Mr. Sexton.
Thank you.
Okay, thank you very much, Mr. Sexton. That's very helpful, thank you.
Thank you.
Right, I think that's probably all we have time for today. I don't intend to go into conditions this afternoon. That we can leave for another occasion.
Yes, I've been asked if you had any particular occasion in mind.
Well, it depends on how we go tomorrow. For one thing, if we have time in the morning, then I'm happy to add half an hour or so on then to look at conditions. Otherwise, then we can leave it until we come back to discuss the 106 obligation and there's still compliance.
Either is fine with us.
Okay, Mr. Goatley?
That's fine by us. Mum, I just wanted to highlight, because you may not have actually seen your emails, and one has flashed up just a few minutes ago. Would it be helpful if I read it out?
Of course, is that any emails to me come via the case officer, so there is always a time lag. So no, I haven't got it yet.
It's a letter from the solicitor acting on behalf of the NHS to Robert Wordsworth, who's your case officer, setting out that she acts for the University Hospitals Coventry and Warwickshire NHS Trust. We understand from the Appellant's Counsel, yep, that's me, that the roundtable discussion will now be dealt with by way of an informal inquiry procedure rather than a roundtable discussion. Please note we have had no confirmation that tomorrow's roundtable discussion is not going ahead except by me telling us so. We further understand that to accommodate the formal procedure, new dates have been proposed as being 8th and 9th of November. Please advise the inspector, the solicitor acting for the trust, and more importantly, the witness who is the author and the expert are not available for the week starting 6th November. However, we are all available 20th and 23rd of November. We look forward to hearing from you. Mum, as in fact I related to her during that conversation, that week is not possible. I'm doing a 4-day inquiry elsewhere in the country. Not a matter upon which you might wish to be making any particularly preemptive decisions tonight, but it may be a matter that we need to then revisit tomorrow morning.
And I'll await that correspondence coming through to me. Usually it comes through very early in the morning because our case officers do start early, so I should hopefully be able to see it first thing. I do accept, though, that there needs to be some correspondence from PINS directly to them. We certainly haven't had time to do that today, but certainly we will need to do that to confirm how things are going to proceed.
Might I suggest that one way, if they won't accept the word of my learned friend, his junior, myself and Mr. Humphreys, that the session is not going ahead tomorrow, might be for you to say so now, and they could play back the video if they wanted to be doubly sure.
That is an option. I think I can confirm at this point in time that the intention is that we are not to have that session tomorrow. And as I explained this morning, for various reasons, I feel it is more appropriate to deal with that matter through witness statements and cross-examination. In other words, a change in procedure, effectively. So yes, I can verbally confirm that now, but I am quite happy to do something in writing as soon as I can, which will be passed through from the PIN's case officer.
I was emailed at, let me just check the time, 4:55, asking if it was going ahead, and I have confirmed at 5:02 that it was not going ahead tomorrow. And Robert Wordsworth is copied into both of those emails. So they do have it in writing from the council that it is not going ahead tomorrow.
Okay, that's helpful to know, yeah. I think it's probably is prudent to confirm that anyway from PINS directly. Yeah, but we can do that in due course. Okay, yeah, Mr Humphreys.
Yes, madam, and just as regards tomorrow's programme, could you, you mentioned something, I just wasn't quite up with it. We've got Mr Osborne in the morning. Then what will we be doing conditions thereafter?
Yes, we have Mr Osborne, first of all, and then his cross-examination and re-examination. Yeah. We were going to have our roundtable on planning obligation tomorrow. Yeah. But in place of that, we could have the roundtable on conditions.
Yeah. But in, sorry, I well understand the other obligation session going off, but in terms of the, the affordable housing, that sort of thing, that's also going to go off until whenever the 2 days are.
Yes, I think the intention was that any matters relating to the 106 agreement, not just the NHS Trust's request, but the other matters we would look at an alternative date. So we will look at issues in relation to affordable housing, the POS, the 3G pitch. There's some questions around that. It's deliverability, design, security, in perpetuity. We will address all of those together.
I think
when we look
it
at the
may have been a discussion that Malone Friends had with you at lunch earlier today when looking at dates. I hadn't realised it had moved on.
Oh, sorry. I thought that was the inference on our previous discussions earlier on today, but that just to confirm anyway. No. That confirms it for you, yes.
No, because I just need to know for when the dates are.
Yeah, no, that's fine. Okay, thank you. So anything further from anybody? No, in that case then, I will draw today's session to a close. And we're back tomorrow then at 9:30. So